The Supreme Court of Nigeria on Thursday, October 26, finally laid to rest the legal dispute over the outcome of the February 25th presidential elections. The court dismissed the appeals filed by the presidential candidates of the PDP, Atiku Abubakar, and the Labour Party's Peter Obi. The court also dismissed the move by Atiku Abubakar to tender fresh evidence of certificate forgery against President Tinubu. He then went on to pronounce on the merits of the petition on issues ranging from the allegation of widespread rigging, the failure of the president to score 25% of the votes cast in the FCT, and the effect of the failure of INEC to transmit results electronically to the IRF portal.
What exactly is the IRF portal? The court below held that the IRF portal is not a collation system. This court, in Oyetola and INEC, made it clear that there is a difference between a collation system and the IRF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IRF portal fails, it does not stop the collation of results, which up to the last election was manually done. Truth must be told, the non-functioning of the IRF may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IRF is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IRF portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IRF portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IRF portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation.
One of the lawyers to the Labour Party, Kenneth Okonkwo, strongly disagreed with the judgment. Amongst other things, he noted that the court was silent on the issue of the money forfeited by the president in the U.S.
As a fine imposed on the second respondent for the proceeds of narcotics and money laundering by the District Court of Illinois. I sat down too. I did not hear it. And I wonder whether that was swept under the carpet or was an oversight, because the lead judgment was detailed on all other issues. And they said all the issues there have been overtaken by event in all our own issues. And I did not hear the issue of the forfeiture. And so That's why I said I disagree respectfully, even though the decision is binding.
A senior advocate of Nigeria, Adamson Adeboro, also shares with Law Weekly his reaction to the judgment of the court.
The Supreme Court has spoken. It's the final court in the land. No appeal can be filed against the judgment of the Supreme Court, except to God Almighty. Be that as it may, the issue of the forfeiture was exhaustively discussed by the Presidential Election Petition Tribunal. And mind you, the judgment of the Supreme Court today was a mere epitome. It just summarized. So by the time you read the full judgment, you will find the decision of the Supreme Court as regards the issue raised by that counsel. I trust the Supreme Court will have. They will have done justice with it. You know, when you hear people saying all manners of things, it is sentiment carries too far. We are talking about justice here, but justice we are talking about here must be according to what the law prescribes. If the Constitution, which is the ground norm of Nigeria, is saying you cannot hold me responsible for a crime I was committed over 10 years, there's something anybody can do. Sometimes you wonder why people sit down in their armchairs and be criticizing Supreme Court justice or the court justices. These people decide matters according to what your law prescribes. They are not lawmakers. They are mere law interpreters. The National Assembly makes the law, but the justices interpret the law and give meaning to the words as used by the legislators. While the Electoral Act 2022 was passed last year, I am sure you are one of those who were jubilating. Say, oh, we have got to our Eldorado. Yes. But mind you, Rome, according to the Victoria Ditch, was not built in a day. Our electoral jurisprudence is evolving. We are developing. Now, what the Electoral Act 2022 introduced to our electoral jurisprudence was beavers to capture, to authenticate those who were to vote. Now, IREF was not mentioned in any of the provisions of the Electoral Act 2022. None. If there was a mentioning of IREF, perhaps in INEC manual or guideline. Now, guideline cannot supersede the provisions of the Act itself. And again, the Act itself, if it's a contravention of the provision of the Constitution says it shall be null and void to the extent of its inconsistencies. Now, if you look at all this, remember that the Electoral Act 2022 gives INEC the discretionary power to adopt any system in transmitting the votes from the polling unit to wherever. Now, if the issue out there is that, oh, INEC promised the entire world that we're going to use IREF. A promise is a promise. It has no legal backing. So here, if they have said so and they resiled from their promise, can you hold them responsible under any law? The answer is no. Those are the arguments I was even expecting them to go and canvass at the Supreme Court. Unfortunately, I don't think such argument was even a canvass at all. That what is the status of INEC manual guideline vis-a-vis the provisions of the Act, the Electoral Act? Like I said, in an electoral jurisprudence, we are evolving, we are growing. We have not yet got there. There are still rooms for amendments to include the issue of IREF right from the polling units to the portal where the entire public all over the world can view as voting going on. our people should stop criticizing our justices. They are doing the work and they are doing it very well. Irrespective of the not conducive atmospheres. We should commend them. We should encourage them. And for the National Assembly, they should listen to the people. They should accommodate opinions. For us to have an electoral heart that will give confidence to the public. But remember, the massive, law-legal latter, law-legal faranda. The law as it is, and the law as it ought to be. So the law as it is today is the law. How it ought to be is an academic issue. So, but the academic issue can be brought into reality if it's incorporated in the law. That's my take on this matter.